Now, what are the actionable problems under the patent law? Infringement of patent rights of a patentee is enshrined in section 104 of the Patents Act. It very clearly states that it is a civil action, is a civil offence, and therefore you would approach for remedy to a civil court. The section 104 very clearly states that the court of least jurisdiction in such a matter is the district court. So, one assumes that if the pecuniary jurisdiction for a given state in which the jurisdiction lies, the territorial jurisdiction lies, is below the mandated amount as per the state rules, then it will lie in the district court. The proviso to section 104 is very interesting. It says that if the defendant files a counterclaim for revocation, then in that case, if the matter is in district court, the entire suit for infringement along with the counterclaim for revocation shall be shifted to the High Court. That means that it is the High Court which has the jurisdiction in this case. We have had an instance where the matter was listed before the district court. This is in District Court Almora, and a counterclaim for revocation was filed by the defendant. The district court judge refused to transfer this case to the High Court as it is required under the section 104 of the Patents Act. The defendant in this case filed a writ petition in the High Court at Nainital for direction to the district court judge to transfer the entire case, the suit for infringement, along with the counterclaim for revocation to the High Court. The High Court at Nainital gave an order to passed an order to the district court judge, district court, for the transfer of files, the entire set of files, to the High Court, since the jurisdiction now lies in the High Court. So, there was a very interesting use of both the civil courts as well as a writ petition in this particular case. In cases, there are also other cases, and we shall go into the remedies in a little while. There are also other instances under the Patent Act where an action is an offence or an action is a civil wrong. One very important action which amounts to a criminal offence, and there are a few which are there very clearly mentioned in section 118, that is section 118 of the Patents Act, which very clearly lists out what are the offences and what are the penalties. And one very important one that we all must remember is the one where the requirements under section 39 of the Patents Act have not been complied with. What does section 39 of the Patents Act say? It says that any person who is a resident of India is desirous of filing a patent application abroad. He must first file it in India, or if he does not file it in India, he must obtain a foreign filing license from the patent office before filing his application in a country of his choice, in any other country. So, under section 39, either you file a patent application in India, wait for 6 weeks and then file it in any country of your choice, or if you do not want to file that patent application in India, then you obtain a foreign filing license from the patent office and then you file your application in countries of your choice. Failure to do so under section 118 attracts criminal action. It is imprisonment and or fine. So this is one of the instances where there is no recourse to correct a wrong. If you have committed the wrong, then there is a penalty. It's a different story that as of now, the Patent Office has not taken any action in any instances that have come up before it. I think in most of the times, people have done the right thing of getting a foreign filing license. But slowly, because of a global platform, because of a number of collaborations between Indian and foreign companies, or Indian universities and foreign universities, or the public-private partnerships that are going on, it is likely that this problem can occur in future. And the only remedy here is, in fact, there is no remedy because it's straightforward a criminal offense. Another very significant one which is available is a declaration of non-infringement under section 105 of the Patents Act, and groundless threats of infringement proceedings under section 106. You may well ask what these mean. And I know that we have tried to use these provisions before the court of law. In the first case, that is under section 105, you approach the court for a declaration of non-infringement. But the problem here is there is no cause of action. It has not happened. The action has not happened. You are anticipating that there is an action that could happen, and you have approached the court for a declaration, a declaratory protection. And this can get extremely tricky. If you approach the court after you have been sued for infringement, the defendant is told by the court that there is no remedy here because he's already been sued for infringement. If the person approaches the court as a petitioner and seeks for a declaration of a non-infringement, then the court says that there is no cause of action yet, and therefore the matter is dismissed. Now, how do we really understand how important this is? This is extremely important, and that becomes very, very important where we are looking at technology benchmarks, technology standards, standardized technologies, standard patents. It becomes extremely important in such cases to have a declaration of non-infringement. The second one is again a very important one, that is the section 106. It talks about groundless threats of infringement proceedings. Now, when it's a normal action by any law firm or by any person who is aggrieved when he feels that somebody is infringing his patent rights, to send what is known as a cease and desist letter. A cease and desist letter is a way of telling the other person, that is the infringer or the alleged infringer, that look, I have a right in this particular invention. I have been granted a patent, and what you are doing amounts to an infringement. So kindly cease and desist from infringements. In almost 90% of the cases, a cease and desist letter is extremely useful, and it immediately stops infringement actions. Most lawyers would ideally ought to use this, and most of the people, aggrieved patent owners, use this. This also gives a leverage to negotiate and to settle the matter, to mediate, to appoint an arbitrator and come to an agreement. In one of the instances where I cannot divulge the name, where a cease and desist letter was issued and served on the other party, the alleged infringer, approached the patent owner and sought for a license and ended up having a very lucrative license arrangement with the previous, as you would call him, the alleged infringer. And that was a very, very useful one. But unfortunately, since it is a trade secret, there is no way I can discuss this and explain that to you as to who the parties involved were. But if under the Patent Act, if there is a case of groundless threats of infringement, then you can approach the court for some kind of a relief so that the court would stay the other party or injunct the other party from issuing such threats. Whether a cease and desist letter amounts to such a threat? No. In my opinion, it does not amount to such a threat where there are bona fide reasons, there is a bona fide cause, there is a bona fide documents which are available, which are appended to this and served along with the cease and desist letter to the alleged infringer. However, if there are letters coming to the alleged infringer on a regular basis by a third party, it could also be seen as a kind of an anti-competitive practice done by a competitor to undermine the so-called alleged infringer and spoil his business. Because after all, at the end of the day, the entire patent law is on the basis of the fact that every patent which is granted by the Government of India shall be worked as a commercial, for commercial purposes.